Welcome to Case by Case. This is a podcast brought to you by Luke Zadkovich and Calum Chain from ZFZ. How are you today, Calum?
I'm good. How are you, Luke?
I'm good. Busy. A lot going on. I'm sure you're in the same boat.
Yeah. The year has kicked off. Well, the year kicked off a long time ago, but it's certainly rolling through now.
Yeah, that's true. We're in March already.
We're in March. Terrifying.
Oh, wow. Definitely flying. Well, look. Why don't we do today's case relatively swiftly? See how that goes. See our listeners, and welcome to our listeners who are joining us for today's episode. Interested to hear whether you like a shorter format. I'm not promising that we'll stick to a shorter format, but we will do our best. We have a tendency to, get into these issues, and it's hard to stop at times. But why don't we keep this one short and sweet if we can, Calum?
Let's keep it short form. See how we go.
So we're going to talk today about London Arbitration 123. This is a case that's reported by the Lloyd's Maritime Law newsletter. We have a summarised version of the award, but it goes for a good 6 pages, and it gets into some detail here. So we've got some good things to talk about. And we're on the topic of late redelivery. So this is in shipping law. We're looking at time charter parties. So a charter party for the hire of a vessel over a period of time, and at the end of that period, the charterers are under an obligation to redeliver the vessel back to the owners of the ship. And in the time charters that we're dealing with today, back-to-back head and sub charters, there was a fixed date by which redelivery had to happen by the 1st of July 2021, and charterers missed that redelivery date, and we're exploring today what happens in that event and what are the damages that charterers can claim, not necessarily in the usual case, but in this particular case, and with reference to the particular clauses that were, clause 119 that had been agreed in this charter party.
Yeah, exactly. And this is against the backdrop of an old but well-known case called the Achilleas, which is seen as setting out basically what happens in this situation. And the interesting thing here is that was not followed. So we have a London Arbitration Tribunal declining to follow a Supreme Court judgment. Obviously, there's a very different situation here, different circumstances, and the tribunal distinguished the Achilleas, but I think this report is noteworthy for that.
Definitely jumped out at me when I read through this one, Calum. I thought, it's a big decision, and it all really turns on this clause 119, and whether the clause does enough, if you like, in the context of this contract and what the parties were held to have known going into it about the facts relating to this charter and what was going to happen after the charter. That is, that the vessel was penned in for dry dock, and sort of be fixed in dry dock, or was updated and maintained in dry dock immediately after the time charter was due to come to an end. And what we're looking at here is whether the owners could claim for the charterer's breach to deliver on time the difference between the charter rate and the market rate for the additional days that the vessel was tied up, or whether in addition to that, so that was kind of the baseline amount that they would have to pay the charterers to the owners, whether the charterers were also on the hook for the loss of a repositioning fixture. And by repositioning fixture, for those not familiar with the term, what that basically means is that at the end of this charter, the vessel is going to be somewhere in the world. I'd have to double check exactly where, but the vessel is going to be redelivered in one place, and it had to then sail to the dry dock place.
Yeah, and I think you'll be forgiven for not knowing where it was, because I think it's anonymized, and therefore they've even gone as far as to anonymize the geography of where this is taking place.
There you go. Okay, so it wasn't just.
It wasn't
mine just a mind lapse, but I hadn't picked that up on the read through. But yeah, so basically the owners had fixed a subsequent follow-on fixture for the vessel to sail from where she would be redelivered to where the dry dock was intended to take place. And because the charters were late in redelivering, the owners missed that fixture. The charters for the follow-on fixture cancelled on the owners because the owners didn't meet the laycan in that subsequent fixture, and owners then had to wear the costs of repositioning the vessel themselves. And it's that it's that repositioning loss, and whether that's recoverable in the context of this clause 119 that we're talking about today.
Yeah, exactly. And so I guess in real short, the owners had done some very clever trading to make sure that this ship had a short but lucrative voyage from point A to point B, and they really needed the vessel to be at point B for this dry docking. And obviously owners were disappointed to have lost that fixture, and that's what they were claiming for, but that goes against the general principle in the Achilleas, which is that the damages are limited to the difference between the contract rate, which obviously the charterer would continue to pay for the overrun, and the market rate if higher. So normally, I guess the normal position in this type of case is that the owner says, well, you carried on paying higher. You were supposed to have delivered by day X. You actually delivered by day X plus 10. The difference in hire rate was an extra $10,000 between what we'd agreed in the charter and what we could have got on the open market had you redelivered on time. And therefore the claim is that $10,000 multiplied by the 10 additional days. And here we're going one step further, and owners are saying, because of the special situation that arose here, and because of the special wording in the charter party, we also get the way that our losses should be measured, I should say, is the loss of that fixture.
Exactly. And I think it's probably useful to just read out this special bespoke clause that did all the work here. So this was clause 119. The charterers warrant that they will not order the vessel to commence a voyage, including any preceding ballast voyage, which cannot reasonably be expected to be completed in time to allow redelivery of the vessel within the maximum period, brackets on or before 1st July 2021, close brackets stipulated in this charter party. If, nevertheless, such order is given, the owners shall have the option, 1, to refuse the order and require a substitute order allowing timely redelivery of the vessel, or 2, to perform the order without prejudice to their right to claim damages, including consequential damages, for breach of charter in case of late redelivery of the vessel. In any event, for the number of days by which the maximum period stipulated in this charter party is exceeded, the charterers shall pay the prevailing market rate if this is higher than the higher rate agreed in this charter party. And that's what you were just saying, Calum. So that last provision is the baseline, and that's that additional difference if the market has gone up, which it had considerably here. So that was making clear that they definitely get that. And that's at law what they'd be entitled to under the Achilleas. The question is whether this reference to right to claim damages, including consequential damages for breach of charter, whether that wording, including consequential damages, is enough to oust what would ordinarily be the case, and enough to say that the parties here had agreed to allocate the risk differently than may ordinarily be the case.
Yeah, exactly. And
thoughts?
Yeah, it's a good one, isn't it? It's an interesting one, and I think who knows? Maybe it's one we see again if it's appealed. It may get there on a point of general importance. But I think the starting point here is really the Achilleas, and what that case was looking at was remoteness. Effectively, the Supreme Court said, well, you've redelivered late, but how could the charterers reasonably have foreseen at the time of entering into the contract that you would have suffered the loss of this new knock-on fixture if they redelivered late? That wasn't in the contemplation of the parties. And I think the idea in this award, and I would probably say in this clause, famous last words if it does get appealed and somebody at the bench turns out to disagree with me, but I would say in this clause is that the parties have identified the normal position, and they're kind of trying to say in a slightly roundabout way, we do get that higher measure of damages. We get those consequential damages. And it's funny, we've spoken to a number of clients about this before. Using the words consequential damages in a contract is a bit of a tricky thing to do, because there are definitions for what consequential damages mean, and it's not normally what kind of commercial person drafting contracts would think of consequential damages as being. It's a type of recoverable loss that's specifically foreseen at the time of entering into the contract. For the kind of lawyers listening, it's your limb 2 of Hadley and Baxendale. But here you've got this express reference to consequential damages, and it seems as though what the parties are trying to communicate is that in the case of a late redelivery, there is a broader category of damages available than there would otherwise normally be at law, and that broader category really almost necessarily would be loss of fixture damages.
Yeah, I'm just not as convinced. I just think where it says right to claim damages, including consequential damages, that they're putting the word including to me puts consequential damages within the realm of damages. And so you're talking about damages that are ordinarily recoverable, but also making clear that if there's any doubt as to whether you get consequential damages or not, you do get them here. But you still need to look to see what does consequential damages mean under law. And I don't know. I have difficulties with it. I also have difficulties as to whether this would fall within the second limb of Hadley and Baxendale in the facts as we've seen them here. I struggle a bit with it. I've got to say.
And taking that point, so the second limb of Hadley and Baxendale are these losses that wouldn't in the abstract be reasonably foreseeable, but were in the special circumstances in respect of which the contract at issue was entered into. So it was known between the parties that you had this special circumstance. That's when you get into this limb 2 of Hadley and Baxendale, and those damages are recoverable at law unless there's a consequential damages exclusion. And here, I couldn't really make out on the facts in this report whether or not the parties were aware of the need for redelivery, because it said at one point that there was this. I think it's the charters were concluded in February 2021. And then on the 7th of May 2021, so after the charter was concluded, the owner sent a message explaining how significant the maximum duration was. So that made me think, okay, well, this is outside of Limb 2. But then later on, there was it said somewhere in the report, I think here, the tribunal.
I think they did say. I think they did say that. The tribunal considered that in construing clause 119, there were two particularly significant aspects of the factual background against which the charter was concluded. One was knowledge that the vessel was due for dry dock in July 2021, and her class certificates expired on 6 July 2021. I think that's what you're going to, and there's also this second factor or factual background that the parties were taken to have known, and that is the market understanding of recoverable damages for claims for late redelivery as set out in the Achilleas. But the Achilleas. But the point here for me, though, is how fixed a date is that dry dock? Like, I understand that a vessel can be intended to go in for dry dock in July 2021, let's say. But here, there's also findings to say that it's routine for class certificates to be extended. It's not like the owners are bound to dry dock after if they want to. If the market moves considerably and they can get some type of extension, then maybe they can push the dry dock back by 2 or 3 months. It felt a little bit like an artificial deadline for the purposes of the second limb of Hadley Baxendale. The tribunal found, however, that that's not the case. They said no, it was understood that both parties knew the vessel was going to go in for dry docking at the time of entering into the charter party. This clause 119, was drafted with that in mind, and as such, it was quite reasonable to think that the owners would line up a repositioning follow-on fixture following from the end of this charter through to making that dry dock. I'm just not sure that the dry dock date correlates with the loss, but with the extra time that was incurred. And
yeah,
I feel like there needed to be clearer words for 4 or 5 days or 6 days or 10 days or whatever it was at the end of this charter party. If charters are in breach of that then owners are going to suffer a loss of fixture. Like, you see what I'm saying? I'm trying to say that if the dry dock can be pushed by a few weeks, right, which was accepted here, and the late redelivery can be expected by a few days, right? There's quite tight timings in this whole thing. Then why is it that owners should be able to recover a fixture that they entered into and didn't allow a long enough laycan on that subsequent fixture to, it almost feels like a bit of sharp practice. No, I don't want to say sharp practice, but it feels almost like you said clever trading at the start. It feels a little too clever for me.
Is there an argument that what the parties were trying to capture under this clause 119 is the cost of having to reschedule the dry dock? That maybe jumps out to me as being a slightly more sensible way of construing the clause. If both parties know that there's this dry dock coming up, if we have to push that dry dock back and we incur costs in doing so, then we want those in addition to the normal market rate. That maybe makes more sense to me.
Yeah, I totally agree. And also, charters ran this argument that the ultimate construction didn't really explain what was meant by clause 1, to refuse the order and require a substitute order allowing timely redelivery of the vessel. Like, there was another option here for the owners to take. And when you think of it that way, is it really intended here that if the vessel is employed on a voyage that should get there, that should be there or thereabouts on late redelivery, should be there on the redelivery date, and it's late, does it really mean here that that's going to then cause a knock-on effect of being able to claim for the loss of the follow-on fixture? I think more needs to be done to do that, in my view. But who am I to say?
Well, it's an interesting one. In the interest of keeping this short and sweet, I think that we've kind of transited the key issues. We've got some interesting comments on it. Maybe we park it and see if we read about this one as an appeal to the High Court one day.
Let's see if it pops up again. It does shine the light also on what is required by special circumstances for the second limb of Hadley. I'd be really interested to know what others think on that. It seems to me that was a bit of a catch-all. If we're wrong on the first, then you get it anyway on the second. And I'm just not sure there was enough here. And of course, we don't have the full award and everything else. But I'm just going on what we've seen here. It just, I don't know. I wasn't entirely convinced. So be interested to see if this one goes any further, Calum. But I enjoyed reading it. If you're interested in redelivery and how it all works, this is a nice, neat one to get the mind going. And I hope you've enjoyed the episode. Thanks for listening in, everyone.
Cheers, everybody. And if you're listening and we're talking about your case, then as some people have done in the past, please do get in touch. We don't get the lawyers' names in London Arbitrations, but we've had a couple of people reach out when we've done these before. So was interested to talk these things through off the podcast.
Yeah, absolutely. And look, these are just personal opinions on a quick read through of the case. So always interesting to see what we make of these things, Calum. But of course, we don't have the benefit of everything that's been argued in the arbitration and all the usual caveats. So until next time, take care, everyone, and I hope you've enjoyed the episode. Please do, by the way, subscribe on our channels. We appreciate it. It continues to build up, and we're really grateful for the listenership that we've got. So thank you. Bye.
Bye.